So in the previous two slides, we have covered the key definitions in this law. Now I will discuss the principal right of the patient under this law, and that is to make a written request for medication. The patient must follow substantially the statutory form. We'll talk a little bit more about that later in the forms section. It must be signed and dated by the qualified patient. It must be witnessed by at least two individuals. That if an interpreter would be required to provide treatment to the patient and is required for the patient to understand the requirements of the law, that has to be included in the form. The language of the interpreter, language of the patient, must be the language of the written request form. And at least one witness and any interpreter cannot be a relative of the patient by blood, marriage, or adoption, a person entitled to any portion of the patient's estate, or the owner, operator, or employee of a healthcare facility where the patient is receiving care. Finally, the attending physician also may not be a witness. Now, I'm going to comment further about the owner-operator bullet later on, because in rulemaking, you'll see that it says something slightly different if the patient is a resident of a long-term care facility. The law requires both written and oral requests of the patient, and they are in the following order. The qualified patient must make an initial oral request. The qualified patient then must make a written request and a second oral request at least 15 days after the initial oral request. Obviously, the law is trying to ensure that the patient truly is making an informed, well thought out decision. The qualified patient may rescind the request at any time and in any manner without regard to mental state. The attending physician must offer the opportunity to rescind through this process. The attending physician must wait 48 hours after the written request to write the prescription order. Next, we're going to talk about all of the attending physician responsibilities under the law. The attending physician is required to make initial determinations of the following: that the patient has a terminal disease, that the patient is competent, that the patient has made the written request voluntarily. They're requesting that the patient demonstrate residency. The attending physician is also expected to obtain informed consent from the patient. Will refer the patient to a consulting physician for the medical confirmation, the second opinion that is required under the law. Will meet alone with the patient, again with an interpreter if necessary, to confirm the lack of coercion or undue influence of any other party. And finally, will refer the patient for counseling if appropriate. If the attending physician has concerns that there is some state of mind issue with the patient, that they may not be making the decision voluntarily, then you are encouraged to refer the patient for further behavioral health counseling. And would also recommend that the patient notify his or her next of kin. Continuing with attending physician responsibilities, he or she will counsel the patient to have another person present when taking the medication and not to take it in a public place. Will inform the patient again of the right to rescind the request and verify immediately before writing the prescription that the patient is making an informed decision. So there are checks and balances built into the process under the law. The attending physician must fulfill all of the medical record documentation requirements, which I'll address in a slide or two, and ensure that all of the appropriate steps are taken as required by the Act. And finally, would dispense the medication directly or contact the pharmacy to make the prescription drug order. Other requirements of this law. The attending or consulting physician who believes that the patient may be suffering from a psychiatric or psychological disorder or depression causing impaired judgment, again, shall refer the patient for counseling. Medical record documentation requirements under the law. The attending physician must ensure that all oral requests by the patient are recorded. All written requests, the attending physician's diagnosis, prognosis, and determination that the patient is competent, acting voluntarily, and acting upon informed consent. The same documentation requirements for those steps taken by the consulting physician, again, the physician that is issuing the second opinion. The counseling report, if any, in the situation, and the attending physician's offer to rescind. Also, the attending physician's note that all requirements of the Act are met and the specific medication which has been prescribed. Perhaps the obvious question under the law for all of you is, am I required to participate? And the answer is no. Nothing in the Act requires a physician to participate. If a healthcare provider, either an individual or a facility, is unable or unwilling to fill a qualified patient's request under the Act, your obligation is simply to transfer all relevant records to a new provider upon request if the patient chooses to seek that consultation and action elsewhere. The Department of Health and Human Services has a role under the law. The statute directs the department to adopt rules within 6 months of the effective date. The rules will require participating providers to file a copy of the prescription or dispensing record along with other documentation requested. And then the department will compile for public view an annual statistical report and file the report with the Health and Human Services Committee of the legislature by March 1st of each year. The enacted law does not address medical certification of the cause of death on the death certificate, but the rulemaking will address this. The statute also says that the state reports may not use the terms suicide or assisted suicide in their reports. And Maine CDC Rule Chapter 15, entitled Death with Dignity Act Reporting Rule, was promulgated in emergency state on September 19th of 2019, the effective date of the law. And the current version of the rule is before the second regular session of the 129th legislature will be considered in January or February of 2020. Other provisions of the Act, the law says that it will have no effect on the construction of wills, contracts, or other agreements, will have no effect on the construction of insurance or annuity policies. The law does not authorize euthanasia. In other words, healthcare practitioners are not authorized to perform the act. It requires patient action to take advantage of death with dignity. It does not lower the standard of care, and it establishes a basis for prohibiting persons or entities from participating under the act. In other words, a healthcare facility, if it's going to direct that its employees may not participate under the act, it has to issue a policy and make that clear to all of its employees. That's not to say that the employee couldn't perhaps serve patients under the law in a different context. I'd now like to speak a little bit further about Maine CDC Rule Chapter 15. This is the administrative rulemaking, mostly on reporting, that has been developed under this law. And remember that rules have the same legal effect as statutes. It simply means that they are created by executive branch agencies rather than the legislature. So Chapter 15 has now been provisionally adopted in January of 2020, pending the legislature's review, because it is a major substantive rule. It's a technical term that simply means the rule has to go back to the legislature for final approval before it is finally adopted. It's important for all of you to know that it does direct the use of a series of state forms, which may be found on the web at this URL, and it sets specific times for using each of these forms. The first of these forms is that written request by the patient. This form is called a request for medication to end my life in a humane and dignified manner form. It is to be completed by the competent patient and 2 witnesses no sooner than 15 days after the first oral request. So you will see that it tracks the law's requirement for the attending physician's obligations. A copy of this form must be provided to the patient. And if the patient resides in a long-term care facility, 1 witness must be a licensed healthcare practitioner designated by the facility. It may be an owner, operator, or employee. And I note that it does not say that it must be the attending physician. And there is an interpreter attachment to this form. If an interpreter is involved, you would use that. The next form is the consulting physician end-of-life care form. This is to be completed by the consulting physician who has examined the patient, reviewed the patient's medical records, and confirmed the attending physician's opinion. This is the second opinion required under the law. The next form is the attending physician end-of-life reporting form. Again, completed by the attending physician, confirming that all requirements of the Act have been met, including the attending physician's responsibilities, documentation requirements, and waiting periods. A copy of the prescription record must accompany this form. The final form is the end-of-life closure form. This too is completed by the attending physician within 30 days of the patient's death. Submission of these forms. All completed forms must be submitted by US mail or encrypted email. Fax is not permissible, to the Department of Health and Human Services, Office of Data, Research, and Vital Statistics, attention the State Registrar, State House Station 11, 220 Capitol Street in Augusta, Maine, 04333-0011. And unless otherwise specified, these forms must be submitted within 30 days of the date on which the prescription for life-ending medication is written. Medical certification of the cause of death. The Medical Association and other commentators have suggested that the electronic death registration system, known as DAVES, enable a clinician to submit self-administration of life-ending medication pursuant to Public Law 2019, Chapter 271, as the primary cause of death, but also to submit a contributing cause of death, which may be the underlying disease. Now, the medical certification of the cause of death is not specifically addressed in Chapter 15. It is a form developed by the Division of Vital Statistics. So we hope that the state agency will accept this recommendation for the electronic death registration system. I hope that this helps you with your understanding and ability to comply with Maine's new Death with Dignity law. Here is my contact information. And once again, I am happy to speak with you about any other questions you may have about this law. Thank you.